Hello, I'm Attorney John Edmond Ruz, and you're listening to this series of Rights of the Accused. Together, we spend a few minutes of the present to gather lessons from the past as an investment for our future. In this video, we will continue to talk about what went wrong with this 2005 case before the Graft Court. No? So first, as I have discussed in the previous video, let me give you a bit of a recap. There was a bit of the problem with the manifestation motion filed by the special prosecutor. On its own, it was not very clear. That would be what I can read between the lines in the Supreme Court decision. Because in fact, portion of the Supreme Court decision says the special prosecutor filed a manifestation motion and manifested based on the recommendation of the retired justice acting as special assistant to the Office of the Ombudsman that the 13 criminal cases, this is the phrase that is critical. This is how the manifestation and motion of the special prosecutor was crafted. It told the court the 13 cases filed against accused were recommended for dismissal, recommended by the retired justice acting as special assistant for the Office of the Ombudsman. So, shortly put, the prosecution told the Graft Court that the 13 cases filed against the accused were recommended for dismissal. So if you will read this, you would think that all the 4 accused would have this favorable order, would benefit from this favorable order, because the 13 cases filed against the accused, although it could be interpreted also that only one of the 4 accused were to benefit from this order. So this phrase caused the confusion, either to interpret it that the recommendation for dismissal was for the benefit of all the accused, or it was for the benefit of only one accused. It was not clear. So on its own, the Graft Court issued an order. However, the Sandigan Bayan failed to check also the other records of the case. For the Supreme Court, the Graft Court was at fault also, because prior to the manifestation and motion that seems like caused the confusion, the Graft Court had a copy of the retired justice's recommendation already. This is part of the decision. I will read it. The Sandigan Bayan or the Graft Court was well aware of the retired justice's report since the special prosecutor appended a copy, attached a copy thereof to his joint reply in compliance with the Graft Court's order. So, according to the Supreme Court, prior to this manifestation and motion, you issued an order, and part of the compliance by the special prosecutor or the prosecution to this order, it made a joint reply. And in this joint reply, it attached a copy of the recommendation of the retired justice. And in that recommendation, it merely recommended the dismissal of the 13 cases as far as accused number 1 is concerned. As far as accused number 2, 3, and 4 are concerned, there was no recommendation for the dismissal of the 13 cases. It was recommended that all 16 cases should be prosecuted. So, the confusion could have been avoided if the manifestation and motion was crafted with more precision and accuracy. And the wrong order could have been prevented if it was based not only on the manifestation and motion alone, but also on the records of the case where there was a copy of the recommendation of the retired justice acting as special assistant for the Office of the Ombudsman. So the Sandigan Bayan interpreted the manifestation and motions contents that the special prosecutor asked for the dismissal of all 13 cases against all the accused. So this was the mistake, no? The manifestation and motion was not drafted or phrased accurately or precisely, and it created a misinterpretation by the graft court, resulting to the wrong order. So in this video, you would learn that these mistakes can happen. So the lesson is, you as a party to a litigation, a litigant, or part of your family is a party to a litigation, you must always be prudent. Understand what is happening. Even if it is difficult to read the documents, maybe try to read and understand the documents with your lawyer, because the concern of a litigant is very invaluable to the lawyer, because you yourself, the litigant, would be the one who would go to prison if convicted, and the litigant would be the one acquitted or be set free if acquitted. So lawyers are advocates, but you cannot leave everything to them, because lawyers and even justices and judges commit mistakes, because these are just people. So you cannot blame them. It would not be helpful to blame them, but what would be helpful is to help them, assist them in every way that is possible. So that would be the lesson of this case. The lesson here is not to point blame on who committed the mistake, but the lesson is to realize that mistakes like this can happen because of the volumes of cases handled by a lawyer or a judge or a justice. These volumes of cases would exhaust any ordinary person. So what a party litigant can do, or a party to a case should do, is to help the lawyer help the lawyer in every aspect that is possible. No? So it depends on your chemistry with your lawyer on how you can help each other. So that would be our video for today. If you like our video, please click the like button, share this to your friends, follow our page, and click the subscribe button. Thank you.